Supreme Court of Canada. Supreme Court of Canada is the highest court in Canada and has a significant role in Canadian justice system. It is expected that judges of Supreme Court be impartial and follow the law, but unfortunately they don't. In civil actions, Supreme Court only accepts a few cases, and when they dismiss the application for leave to appeal, they don't explain their reasons. This is power with lack of responsibility, which amounted to dictatorship. When I filed an application for leave to appeal, it had all elements for acceptance and important issues for the entire nation, like charter rights, involvement of tens of thousands educated Canadians, and contrary decisions of different courts across Canada as well as Supreme Court itself. But the Supreme Court dismissed it without any explanation. I agree that we must have powerful and independent justice system, if and only if the judges, among other requirements, be impartial and honest. Wrongdoing of judges, and especially the Supreme Court, undermines justice system. It is always possible and acceptable that judges make unintentional mistakes, but intentional mistakes, violating constitutional rights and writing 80 pages false justification to support a litigant will destroy justice and society at large. I was trying to find out why Supreme Court dismissed my application for leave to appeal. And few months later, I found a judgment of Supreme Court in January 2017 in case of Ernest versus Energy Board of Alberta. As long as in this case, like mine, a regulatory body was involved, I realized how Supreme Court have full and unconditional support for regulatory bodies. For being a dictator, you don't need to be king or president. A judge who enjoys the power and abuses his or her power is a dictator. Dictatorship is not a name, it is a character. In the split 5-4, or actually 4-1 judgment, Chief Justice and 3 other judges believed in charter rights and made these comments. Quote, with respect to good governance, 2 interrelated principles must be kept in mind. First, charter compliance is itself a foundation principle of good governance. Second, good governance concerns must be considered in a manner that remain protective of charter rights. End of quote. But majority of judges didn't agree and made following comments. Quote, underlying the question of whether charter damages could be an appropriate remedy for a remedy is a broader issue. It concerns how to strike an appropriate balance so as to best protect 2 important pillars of our democracy: constitutional rights and effective government. Charter damages may vindicate charter rights, provide compensation, and deter future violations. But awarding damages may also inhibit effective government. Good governance concerns are also engaged, as granting damages would undermine the effectiveness of the board and inhibit effective governance. Charter damages would be contrary to the demand of good governance. End of quote. Please note that all over the world, Dictators justify their action by demands of good governance. And here Supreme Court believes that effective government and demand of good governance is pillar of democracy and is contrary to constitutional rights and charter rights. How in a civilized and democratic country Supreme Court can declare that demands for good governance are contrary to constitutional rights or constitutional law? Another quote. Allowing claimants to bring claims for damages against the board has the potential to deplete the board's resources with respect to both funds and time. This shows that Supreme Court is not impartial. It is plain and obvious that a judge who is worried about the resources of a litigant cannot be impartial. Another quote. The immunity is broad and has been applied even in the face of alleged human rights infringement. End of quote. This is the conclusion of Supreme Court of Canada, whose government brings resolutions for human rights infringements of other countries in United Nations and defend human rights of peoples in other countries. Government of Canada thinks that it doesn't have duty to defend human rights of Canadians with the excuse that Canadian justice system, unlike other countries, is independent. Another quote. On its face, S43 is a total bar to any action in proceeding whatsoever brought against the board by anyone in all circumstances. Section 43 destroys all rights of action and entirely eliminates the ability of any and all persons to even start a lawsuit against the board, regardless of the nature of the claim. End of quote. Here, Supreme Court is against Canadian fundamental right to have fair access to justice. It is interesting to note that this is contrary to their own judgment in Finney versus Bureau de Quebec. Even if that judgment was special because of one of the litigants or both of them, it is Supreme Court fault that didn't clarify it. Supreme Court cannot punish us for following law or Supreme Court precedent, and if someone is to be punished and pay costs, is Supreme Court itself. Another quote. Immunity is justified because the law doesn't wish to chill the exercise of policy-making discretion. Quintessentially, the board is a state actor whose responsibilities are of policy-making and adjudicative nature. By protecting judicial and quasi-judicial decision makers from having to defend their decision against damages suits, the immunity simultaneously strengthens public confidence in the legal system, preserves impartiality both in fact and in perception, and closes off routes for collateral attacks. The second provision is an immunity clause protecting an administrative tribunal, like almost all quasi-judicial and judicial bodies in Alberta and the rest of Canada, from being sued for damages. This protects the public interest by ensuring that adjudicative bodies responsible for making independent decisions are not casually or cavalierly dragged into litigation that drains their attention and public resources. Among other Canadian statutes, the Court of Justice Act providing immunity for judges, masters, case management masters, and judicial counsel. The jurisprudence also confirms that judicial and quasi-judicial decision makers are protected by common law immunities. It is important to bear in mind that these immunities are there not for the benefit of individual judges. Rather, they exist for the benefit of the community as a whole. Indeed, an independent judiciary free from improper influence is an essential component of a free and democratic society. The same analysis applies to quasi-judicial decision makers, which is why legislatures and parliament have extended statutory immunity to administrative boards and tribunals. Further, this court has already accepted an immunity that protects regulatory bodies from negligence claims that arise from the policy decisions they make. It is worth noting that this court has found charter damages to be available on only 2 occasions: in response to a charter breach resulting from abusive police conduct toward a detained suspect, and in response to a charter breach resulting from a prosecutor's inadequate evidentiary disclosure to a criminal accused. End of quote. It is good that Supreme Court, at least in 2 cases, accept priority of charter rights to immunity. But they don't answer that in other cases, why the regulatory bodies are more important than police and prosecutor, or the educated people abused by regulatory bodies are not as important as detained suspects or criminal accused. Supreme Court must realize that they have to follow the law, not making law. Lawmaking is sole responsibility of Parliament and is out of jurisdiction of Supreme Court. Charter rights is available for all Canadians. Supreme Court is totally wrong. To justify immunity of regulatory bodies, they behave badly. Supreme Court is not above the law. Canadian Constitution is the supreme law of Canada, and nobody is immune to infringe charter right. They insult the audience consciousness and try to mislead the people by calling total immunity, which is barbaric law of dictatorship, as principle of democracy, and for the benefit of community and not for individual judge and regulatory bodies. Section 52 Constitution Act 1983 says, "The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of inconsistency, of no force or effect." This section of the Constitution gives the court the power to rule that a particular law is not valid if it violates the Charter, which is itself part of the Constitution. So, immunity is not valid. Judges of Supreme Court intentionally try to mix up the words and ideas to justify their wrong assumption. In many paragraphs, they explain immunity of regulatory bodies in policy-making decisions. And in other paragraphs, they expand it in, to total immunity. This position of Supreme Court creates confusion in lower courts as well. Some judges believe in total immunity and some others believe in immunity in policy making decisions and not execution of policy. The Supreme Court doesn't clarify that if immunity is for policy making, why expand it in total immunity? And if it is total immunity, why justify it with policy making decisions? Judges of Supreme Court try to induce that these immunities are not for the benefit of judges and quasi-judicial or regulatory bodies. Rather, they exist for the benefit of the community, free democratic society, strengthen public confidence, and preserve impartiality. Reality is vice versa. Even Supreme Court itself is not impartial because of enjoying immunity. To justify immunity for regulatory bodies, Supreme Court compared them with judges and justice system. While at least on paper, even the judges don't have total immunity, because by law, according to Judges Act, anybody can file complaint against a judge. Also, as long as everything a judge say in the court is under oath, if a judge lies, he or she commits serious crime. I know that these are only on paper and not in reality, because the system doesn't follow the law. Also, judges must have requirement for appointment as a judge and must follow the law, be impartial, honest, have integrity, tact, and so on. But regulatory bodies don't have any procedure for decision makers who sometimes are unknown volunteers. For example, in my case, even PO didn't know who made decision on my file and why. The judge who was in their side and defend them better than their counsel wrote, quote, "While I and likely PO prefer that ARC's decision provides further particulars as to why it chose to focus on plaintiff's exam towards a chemical engineering discipline." End of quote. It means that PO didn't know who made decision and why. But Supreme Court call it benefit of community, free and democratic society, strengthen public confidence and preserved impartiality. Supreme Court says legislature and parliament extended statutory immunity, but doesn't know or forgot that this in acts which was enacted in 1990 in the province of Ontario, these clauses are conditional, and in the same section they imposed responsibility as well. Also, it seems that it is Supreme Court's responsibility to know that Bill 189 in 2002 and Bill 70, Removal of Occupational Barriers Act in 2003, enacted by same legislature, among other things like equal opportunity, states in paragraph 8, an individual adversely affected by an act or omission of an occupational body in alleged contravention of this act may bring an action in the Superior Court of Justice. And if the court finds that this act has been contravened, it may make such order as it considers appropriate to enforce this act. This these bills show that Supreme Court opinion that immunity clause bars any action against regulatory bodies is wrong and illegal. Supreme Court never asked regulatory bodies to follow the law, regulation, and don't abuse community. These regulatory bodies act like a spoiled child who abuse others with full support of parents. During my search, I found 4 judgments of Supreme Court which regulatory bodies were involved. 2 of them were Edwards and Cooper in 2001, which are used as referral in many courts as well as Supreme Court in earnest. While in these 2 cases, the plaintiffs were someone who suffered loss at the hands of a regulated professional who wanted to claim against the wrongdoer's licensing body, and are not similar to other cases whose regulatory bodies are involved directly. The third one was Finney versus Bureau de Quebec in 2004. It is interesting that this is the only case which Supreme Court ruled against a regulatory body and find out that serious recklessness or carelessness amounted to bad faith. This was a new translation of bad faith, which was never accepted and referred to again, neither by Supreme Court nor by lower courts. This is an evidence that court, instead of applying concept of common law system, look at it as a magic box. It seems that judgment for Finney was somehow special. While many lawyers thought that this case may open a new window to make regulatory bodies more accountable. It never happened again. And in this system, in judgment between rich and poor, powerful and weak, law is only on paper. When court hides your evidence for appeal, when courts hide your evidence for complaint and inform you that the judge ordered to keep it because you want to complain against him, how can you talk about rules of law? The assumption of the Supreme Court about the immunity of judges and masters is also totally wrong, because lawmakers believe that they must have all requirements for the job. When a job appointed as judge with lies in his application or questionnaire and continues lying in his endorsements by full support of justice system and keeping the evidence as confidential, and the master, among other lies, suspects the court system for delay and wrote the quote, "I accept that due to delays in the court system, the motion could not be scheduled to be heard for some 6 months. This is not the fault of the defendant." End of quote. Despite that the defendant accepted its fault in its affidavit. I asked judges of Supreme Court, especially Chief Justice and 3 judges who defend charter rights in earnest, to respect law and Constitution of Canada. We respect law if and only if government and justice system respect it.